Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to the third installment of the Novus Law Firm and Fortney Scott's Back to School webinar on higher education, post-COVID-19 legal and compliance concerns. This briefing will be recorded. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's webinar is a discussion of recent changes to the Families First Coronavirus Response Act, administering requests for reasonable accommodations, and privacy law issues to consider when returning faculty and staff to campus. The presenters include attorney Natasha Baker from the Novus Law Firm and Fortney Scott attorneys Elizabeth Bradley and David Fortney. I will now turn the program over to David Fortney to start our webinar.
Well, great. Thank you. And good morning or good afternoon, depending on what part of the country you're in. It's great to be with all of you again. And Natasha and Liz, great to be with both of you virtually, but to see your respective boxes on the screen. So today represents, we last got together a couple of weeks ago, about a month ago, and have been focusing on the higher ed challenges, particularly the higher ed institutions, the challenges that they face in responding to the COVID-19 crisis. The landscape, frankly, hasn't gotten any easier or clearer. And so part of what we want to do today, and we'll talk about our detailed agenda, but basically we want to spend 2/3 of our time giving you the updates, the key updates, and there have been some significant developments, as we all know, to make sure that we're all up to date. And then we also want to be sure and answer your questions. And this is really directly a result of feedback we have gotten from our prior webinars, where a number of participants have said, in essence, geez, we would like kind of an open opportunity, more of a roundtable to throw some questions in and let our subject matter experts, Natasha and Liz, deal with those. So that's the big picture of what we want to do. Let's go through. Valerie, next slide, please. Obviously, today we are going to provide you with a number of legal and related updates, but the purpose of today is to make sure that you're aware of those updates, not to provide you with specific legal advice, that every participant on this call is encouraged to speak with their either their own counsel in-house or their outside counsel to ensure that for their specific facts that they receive appropriate advice. Next slide. The agenda, and this is what I mentioned briefly, but we're going to drill down on this. There have been some developments on the FFCRA, the Family First Coronavirus Response Act. That's the relief act that was passed last March and April that we've all been living under, that deals with the expanded family and sick leave. We also want to drill down into the request for accommodations that we're seeing from clients and privacy considerations. Frankly, each of those primary bullets could occupy more than the hour that we've allocated. So both Liz and Natasha are going to be very measured and hit the high points for you, but we can flesh out, and I would encourage you to raise your questions. There is the chat box, and I think at this point everyone's familiar with the protocols on how to enter a question. And part of what I'm going to try to do is make sure that we do get through all of your questions and get them answered. So with that, let's jump off. And next slide, please. So let's start with the FFCRA update. Liz, I think you're up.
Hello. Thank you all for joining us.
Good morning.
So we wanted to touch, thank you. A fairly significant modification occurred in a court decision for the FFCRA leave provisions. And so move on to the next slide, specifically, the State of New York versus the USDOL opinion came out on August 4th. And it has significant impacts on both the emergency sick and the emergency family leave provisions of the FFCRA. We're going to walk through each one of those provisions in greater detail, but highlight it modifies the work availability requirement that was in the DOL final rule. It modifies the definition of the healthcare providers that was in the DOL final rule, changes when intermittent leave and for what reasons intermittent leave can be used. And in addition, it modifies the requirement about when documentation needs to be provided. So we're going to walk through each one of these in greater detail. Natasha?
Yeah, and just as a reminder, so the FFCRA was passed, as David said, back in March, which seems like a lifetime ago. And then what happened functionally was that the Department of Labor issued its final rule, essentially interpreting and providing additional guidance for employers when trying to understand and roll out and quickly implement the FFCRA. And so this has been sort of a difficult rollout for employers. So people were watching this New York case pretty closely. And then, of course, as Liz said, the decision came out last week. And then one of the significant elements of that decision was the context of the work availability rule. So if you recall from our prior webinar, if you read the Department of Labor final rule, it stated that employers were not required to provide the paid sick leave or the emergency FMLA to employees who didn't have work for them. And that applied to 3 of the bases for the sick leave and the only reason for the FMLA. And so just as a reminder, if you didn't join us on our prior webinars, or if this is new to you, the bases for the paid sick leave are if someone is quarantined, if someone has been advised by a doctor to self-quarantine, if they've got symptoms and are awaiting a diagnosis, and then if they're also caring for someone who's been quarantined, if they're caring for someone who's medically self-quarantined as advised by a doctor, and then if they have childcare issues as a result of the school or place of care being closed due to COVID. So this is those are sort of the reasons that people could initially apply for paid sick leave, paid FMLA leave, and then what functionally happened was this question of, well, does the employer have available for the person as a threshold issue? And as the final rule said, you don't have to provide the sick leave if you don't have work available. The Southern District of New York disagreed with this analysis and basically vacated the inability to work exemption. And so now this sort of threshold issue of was there work available as a result of the operations. And we saw this more outside of higher ed than inside higher ed, but it's also could be for people whose positions don't allow them to work remotely due to campus closures. We saw this with facilities, grounds, things that couldn't be done sort of via Zoom, that the work was just simply unavailable. The Southern District of New York rejected that sort of threshold and vacated that. So significant change insofar as it now impacts the eligibility of those who are going to try to access paid sick leave or FMLA. So we wanted to bring this up right away in this webinar because that was a sort of significant change in terms of how the Department of Labor was interpreting it, and now this how the District of New York is interpreting it. So we'll start there and we'll keep going with some of the big changes that decision had. Liz, I think back to you.
Yeah.
Another significant change is the definition of a healthcare provider. Now, this is going to impact for universities, your student health centers. So thinking about that, and obviously has greater ramifications outside of the healthcare, the university setting. Excuse me. But thinking about your health centers under the FFCRA, it exempt healthcare providers, and it cited to the FMLA. The FMLA definition is fairly narrow. It's here in front of you. It's a doctor of medicine who is authorized to practice medicine or surgery, and it goes on a little bit more, but or other person determined by the secretary to be capable of providing health care services. So a key in the FMLA definition is providing health care services. The FMLA does provide some samples of or examples of the type of jobs, obviously doctors, podiatrists, dentists, clinical psychologists. So it gives actual treating type practices and job titles as an example. The DOL final rule was much broader than the FMLA. And it's anybody employed at any doctor's office. So the scope of the DOL rule essentially goes all the way down to your secretaries, your janitorial staff, anybody performing any duties within a doctor's office. So the Southern District of New York has come back and said that is far beyond the scope and intended purpose of the FFCRA and who they wanted to exempt from these leave provisions. So they have vacated the Department of Labor's broad definition and have scoped it back to just those individuals who would meet the healthcare provider definition under the FMLA. So this is a drastic change, and we're going to talk about next steps. But this it allows leave for a substantial number of types of employees that were previously exempted under the Department of Labor rule. And the next piece that I looked at was the intermittent leave. Natasha, do you want to discuss this?
Sure, yeah, and it's too bad we can't see everyone on the webinar because I'd love to just see a show of hands for people who love administering intermittent leave under the FMLA. Yeah.
No one. No answers.
So just to make this a little more fun, so if you recall, if you looked at the guidance, the Department of Labor's rule had barred intermittent leave absent the employer's consent, and they really made it very, in my opinion, difficult to implement any form of intermittent leave unless the employer was consenting. And so what the court said was, nope, again, beyond the scope of the FFCRA here, and you can't just have a blanket bar on intermittent leave. You can, for obviously people who are out, who are eligible for FFCRA, or FMLA leave, who are contagious, who are self-quarantined, like those people don't have to be allowed to intermittent leave and come back in and come back in. Like that's not reasonable. But for the other permissible leave reasons, particularly in what Liz and I are really going to unpack here in the middle of August, is permissible leave reasons, including the childcare for those whose schools are closed or childcare areas are closed. So those people can access the FMLA intermittent leave, and we don't have this sort of overarching employer consent barrier that was implemented under the Department of Labor rules. So again, another significant change in terms of how you're going to be administering these requests for leave. So, and then you're gonna take the fun documentation part.
And the last significant change that came out of this, or interpretation out of the Southern District of New York, was the court held that the DOL's final rule included notice provisions that were starkly contradicted those that were in the FFCRA. So specifically, for the emergency family leave, the FFCRA required or said notice as practicable when leave was foreseeable. For emergency paid sick, the FFCRA said that the employer may require compliance with reasonable notice procedures. The DOL's final rule then required that the documentation for both types of leave, either type of leave, must be provided prior to taking that leave. That's a more burdensome standard than we currently have under standard FMLA or most standard sick leave policies, requiring that notice in advance prior, especially in light of difficulty seeing doctors right now, getting in to get that notice provision. So the Southern District of New York found that one, the DOL rule contradicted the act. In addition, the burden and practical requirements of it were not able to be met by most employees. So they have vacated the requirement that documentation must be provided prior to taking leave. And I can just see practically, most people weren't requiring it in advance. They were sort of following their prior FMLA, their standard sick leave policies. That usually was somewhat of a normal, reasonable requirement.
So I was curious what you were seeing there in terms of whether people were able to provide that documentation, because what we saw all summer is that people were not able to provide that documentation. So that part of the decision wasn't that much of a surprise, but it seemed like, at least out here, that the documentation was tough.
Absolutely. We would see employees giving emails or communications where they're trying to get in with their doctors. I'm trying. I'm doing the best I can. And nobody's going to argue and say, oh, you have to come into our workplace and get the whole workforce sick without getting the signed document. So I wasn't, the notification provision, I wasn't surprised at all to see that response inside the court. So we kind of walked through what the changes were, but now we want to talk about what is the scope, what is the application of it, and then we're going to get through these, and then we'll turn it over to Natasha, who's going to talk about sort of what are your next steps. So first of all, this is an opinion out of the Southern, can we go back one slide? Sure. So this is an opinion out of the Southern District of New York. How broad is this application? Does it only apply to employers with employees in New York, or this is interpretation of a federal act and USDOL final rule? Does it have a broader application? Right now, I think it is only applicable in New York, but I think that's a very difficult, a very potentially dangerous compliance approach to take. Other states could bring this opinion up. There could be other courts that can cite to this. So a conservative compliance approach is to take these interpretations of the Department of Labor final rule that is put down by the Southern District of New York and apply it across the country. And I think that is likely the end result of this. If this opinion does not get appealed and this opinion stays, I do think that that's going to be the interpretation that it will apply more broadly than just to New York. Tasha, your thoughts on that?
Yeah, I mean, I also agree. I think like one thing I looked at was the Texas opinion a couple years ago that struck down the Department of Labor's guidance on wage hour, and that court was very clear about the scope of its decision, whereas the Southern District of New York was not clear about the scope of its decision. So I've seen some thought pieces and some media out there that say, well, this is only Southern District of New York. You don't have to worry about it outside of that jurisdiction, and I think that's dangerous. Like that's why Liz and I were trying to point out, like, some of these things seemed pretty obvious. Like, okay, they're exceeding the scope of their authority to request documentation in advance. I think another court outside of the Southern District of New York is going to follow that same analysis. The intermittent leave, based solely on an employer consent, I think that's another one that courts outside that jurisdiction would follow. So I'm in California, so we know where they're going. We know where the Ninth Circuit would end up. They would likely follow the Southern District of New York. So I think if you are going to continue to rely on the Department of Labor guidance and you are outside of the Southern District of New York, you should do so in consultation with your counsel, fully aware of the risks, because as we proceed through, it's August, campuses are repopulating, K-12 is opening and probably closing back down, as we're seeing. So these issues are going to be very real, and there's going to be a lot of volume around these types of requests in the next few weeks. And so if you're not going to follow the Southern District of New York decision, that should be a decision made with full knowledge of the risks in consultation with your counsel. So I wouldn't rely on some of the pieces that say don't worry about it. It's making me nervous.
Well, one thing, can I just add one thing that I think is interesting? The Labor Department could issue some sort of response. It could issue interim guidance. It could issue any statement. It could indicate whether they're going to appeal or modify their enforcement. They have sat very Sphinx-like and helped create, this would be a criticism I have of DOL, they have allowed uncertainty to continue. Their initial regulation has now been rejected by an informed decision. It's problematic. The timeliness of it, as you both pointed out, is so critical. It would be nice for the Labor Department to sort of raise its hand and say, listen, as an interim measure, here's what we think you should do. But they have not, which just increases the uncertainty even more than is necessary, in my view. Okay. Good.
The next question is there, sorry, going back, sorry. So the next question is there retro applicability on this? Or if you made decisions based on the rule as it stood, is this some sort of problematic for your prior decisions? And I say no. You're not going to be found in violation because you relied on the Department of Labor's final rule in interpreting who was a healthcare provider or interpreting whether intermittent leave can be taken. So I don't think there's potential non-compliance based on retroactive active, but as we will talk about in a moment, we do think that there's some retroactive actions that you should be taken for your compliance considerations. And with that, is there going to be enforcement? So that's something to be thinking about too, depending on what the DOL issues, interim guidance. We just don't, they're the ones who wrote the final rule. So if you don't follow the way the rule was written, are they going to come after you for that? I just don't see the DOL going after enforcement for you complying with the way they wrote the rule and what they wanted the rule to be. But we can move on to the next slide to talk about what we think your best practice next action should be with regard to this.
Yes, and so in light of all these changes, and we left plenty of time for Q&A, so feel free to hop in the comments if you've got additional Q&A on this. But in light of this, you want to go back, look at the FFCRA leave. Are you a covered employer? If you're a smaller institution, that's going to be really critical for you to assess. For those with less than 500 employees, determine how this is going to apply to your workforce. How are you going to implement this? Particularly, as I said, the volume of cases or requests are likely to increase for the qualifying reasons related to childcare or closure of schools. And then look at those leave policies. We're also been doing a lot of back to school review of handbooks. Liz, I know you have as well. And so you've got a decision to make whether you want to put this in your faculty and staff handbooks, whether you want to have a standalone policy, but just making sure the eligibility provisions are updated. You may want to go back and review who you've denied. Did you just recently deny someone? And then take a look at those denied intermittent leave requests. So just some compliance actions there. And then I think we're going to go now to the next slide to talk about, for even those of you who are not covered by FFCRA, there's still more legal changes to consider.
Yeah.
Some coming.
So in this next section, oh, go ahead. I was going to hand it off to you, right?
Yep. So this next section, we're going to talk about returning to work and the reasonable accommodations and workplace modifications, what we're seeing, what some recommendations are, and a part of that are some of the privacy issues and concerns that are bubbling up with all of these as well. And part of this, we want to start with some baseline standards here again, because we're seeing a lot of these questions about who are we required to give a reasonable accommodation to, what type of reasonable accommodation, and a lot of that crossover between what is a disability under the ADA versus the various categories of people under the CDC definition. So as first, our baseline, the ADA. So who is an individual with a disability under the ADA? And so it's a person who has a physical or mental impairment that substantially limits one or more major life activities. So it is not just a diagnosis here under the ADA. It is that looking at whether you're substantially limited one or more major activities. So that is an important piece, and kind of put that in the back of your mind, because we're gonna ping to that here in a minute when we start talking about the CDC. Another is a person who has a history or record of such an impairment, or a person who is perceived as having such an impairment. And some of these standards are more of who has standing to bring litigation under the ADA, but for the purposes of a reasonable accommodation, it is a person with a physical and mental impairment that substantially limits one or more major life activities. So then the next definition is relevant to us is looking at the vulnerable populations. And so CDC has come out with a definition of vulnerable populations and also a definition of people who are at higher risk. So first, under vulnerable populations, that is people who, because of their unique needs, standard emergency responses may not be available. Those are people who have difficulty communicating, difficulty accessing medical care. Those people may need help maintaining their independence. Those who require constant supervision, or those who may need help accessing transportation. So this is part of the vulnerable population definition by the CDCA. And then they have drilled down further on that with their definition of people who are at a higher risk. And this is where there's an interplay between the definition of people who are at higher risk and the ADA reasonable accommodation and whether they're an individual with a disability. And so we're going to spend a little bit of time breaking this down. So who's an individual who are at risk? The first one is somebody who is over 65 years of age. Next is living in a nursing home or long-term care facility, chronic lung disease or moderate to severe asthma, immunocompromised individuals, cancer, smoking, bone marrow. There's examples here that they've provided. Severe obesity, diabetes, chronic kidney disease undergoing dialysis, or liver disease. So these are some examples. But let's break all of them down. Just because somebody is an individual who is at high risk does not necessarily mean that they are an individual with disability. They may be. So look at this. Somebody who's over 65, just because you're over 65 does not mean that you are substantially limited in one or more major life activities. So that just the definition of people at high risk because you're over 65, you do not necessarily qualify as an individual with disability. I would also say just because you smoke, you are not an individual with a disability. Some of these are obvious, right? What about diabetes? I think that, diabetes is likely going to qualify as an individual with disability because of some of the side effects, and often diabetes does limit one or more major life activities. So just the analysis still needs to be done. If somebody comes to you and says, I am in one of these categories, you need to be looking at whether they qualify as an individual with disability. And we're going to talk about maybe you don't want to get involved in that. And I think Natasha in a few minutes is going to talk about some of the policy considerations. There's decisions to be made about how do you treat these various categories and whether you want to just set a policy that they do get a COVID-related modification. So the next thing we do, and I just kind of touch base on, and I think I've sprinkled this in the rest of my discussions, is the legal obligation under the ADA to provide a reasonable accommodation, and that is a term of art, is only to those individuals who have a disability. So if an individual has a disability, you are required to engage in the interactive process, provide a reasonable accommodation to the qualified individual with a disability, unless doing so would cause an undue hardship. This is where you start having that back and forth discussion about what they've asked for and what you can provide. Are you making facilities accessible? Is there some job restructuring to accommodate and for their disability? Do they require equipment, modification of equipment? Those are the standard examples of the ADA modifications. Yes, Natasha.
I just want to chime in on the undue hardship. That does not mean what people think it means. So we've spent all summer talking about undue hardship. Undue hardship is measured against your institution's operating budget. It's not assessed department by department. It doesn't mean that it's hard to do. It doesn't mean that it's difficult to do. It's a pretty high bar to meet an undue hardship. So sometimes that term is in there, and then people say we can't do this. It would be an undue hardship, but that we got to really unpack that, because that's a hard standard to meet. And so the better practice is just to go through that interactive process, see what can be done, see what can't be done. No one may be happy with the results in the end, but I would not rely on just a blanket denial based on undue hardship, because it doesn't necessarily, it's not as simply as interpreted as it may seem to be. And then just as a reminder, in California, interactive process is a separate standalone violation for failure to engage in that.
Yep.
And then we have a slightly more permissive definition of disability. It's not required to be substantially limited. So if you have any of these things popping up, the net result may be the same, that someone's request to simply just work from home is not a reasonable accommodation, but it's a process that you have to go through. So just making sure that they are a qualified individual with a disability and invoking that interactive process is really what needs to happen. And then if it's not disability, right, then as we talked about in our prior webinars, and I know Liz and I and David have designed this with our clients, is, well, but then there's this whole other category of people that still need workplace modifications. It may not rise to the level of disability. It may be that they're over 65, they may be a smoker, they may be fearful. Like, there's all these reasons that people may want a temporary modification. But you can see where, because the ADA process is so prescribed, so precise, has such defined terms of art, you don't want to run somebody's request to work from home because they're nervous or because they live with someone who's immunocompromised through your ADA process, because it just doesn't fit. It's just not the same process. So we're really recommending a separate temporary modification process, really making sure that it's called a modification, not an accommodation. Again, administering this centrally, this is new, this is different, this hasn't been done before. This is ripe for ad hoc, discriminatory, disparate treatment, decision-making. Like, really centralize it, define the permissible reasons, what is needed in the department, what's allowable within the particular school, what's the function of the job, can it be performed remotely, because that tends to be the one that people request the most. And then from there, you can assess, well, no, you can't work from home as a temporary modification, but we can provide you PPE, we can provide you a separate entrance. It almost functions at the end like the ADA interactive process, but it's clearly separate. And then what we've also seen, and I'd be curious what you guys are seeing, is during that temporary modification process, an employee may say, I want to work from home, I'm really nervous about coming in, I'm nervous about the campus reopening. And then during that, they disclose, because I have diabetes, because I have severe asthma. And so the key thing there is that may flip the switch to get you over to the disability process. And so, it's this, it feels like this weird legal fiction, and why not combine these? But the legal obligations are really quite separate and distinct. So we'd recommend sort of a parallel approach with the reminder that you can flip that switch and move it over to disability. And just 5 seconds on a soapbox before we get to the next slide, and that is, make sure you've got your Section 504 coordinator designated, the information available, so that on your website, your statement of non-discrimination, those seem to have disappeared over the years, and so I'm really trying to do a PSA on getting those back in. So soapbox complete. So go through your process. You have to also, if you're a covered employer under the FFCRA, under 500 employees, the results of somebody not being able to work may result in the FFCRA being tripped. If you say, as a result, you cannot work from home. So this is why we really think that centralized process is going to be important. So all of those compliance checkboxes are being checked as you think about the ramifications of this. You want to have a provision for termination of modification. It may be that this particular workplace modification was fine for a month, but as for a long-term business strategy in that department, it doesn't work. And then what happens if people breach that agreement? So really, just thinking through all of this, like, this is completely uncharted territory. It's about to fully reopen, and I think we'll just move to the next slide before I get on another soapbox.
Well, actually, let me go. I've got a little one on that one. is you, and Natasha made it very clear that this needs to be a centralized, and this was one of the questions that was set in prior to that wanted to be addressed. Absolutely a centralized process. Also, we say the policy needs to be different. Don't use your ADA policy for your COVID modifications. But that doesn't mean that the team that works on your ADA accommodation decisions should not be involved in your COVID modification decisions. If you can be the same team, they need to put their different hat on and use slightly different practices, but that team is already trained and knowledgeable about what is an ADA triggering disability. And they're going to be trained to know, I'm having a COVID conversation. Oops, somebody mentioned a disability reason, and they will know to move that over. And that way you're not missing your ADA compliance. So separate policies, separate procedures, but if you can centralize that with the same group, that is probably going to be the most efficient and effective way to do these COVID modifications.
Yeah, 100%, Liz. Like, we had schools that set up like almost like a little task force or a review group to say, okay, these are the people who are going to look at this system-wide, make decisions against clearly articulated factors, because there's an enormous amount of pushback on who's making these decisions, what are the eligibility factors, why can't the faculty be involved, why shouldn't this department chair be involved? Like, people want to be in on these modification decisions in ways that really impact the affected employees' privacy and what is traditionally within the realm of privacy rights covered by your HR process. So yeah, really great point on the teams. So, you know, you can see modified work schedules. The common requests are remote work, partial remote work, job sharing, pre and post business hour work, really trying to, again, maybe you need to end up tying that into now permitted in the Southern District of New York, intermittent leave requests for sort of when somebody's going to either job share or work part-time or work differently. Please run any job sharing requests by council. There's a lot of wage and hour issues that are coming up with respect to job sharing, and if people don't meet the exempt status. So some of the ideas that, you know, could be helpful also need to be vetted for compliance. And then, you know, there's been this huge question this summer about what are people doing outside of work? They're asking for all these modifications. They say they don't want to come to campus, and then, you know, they're out and about, and people see them, and people take pictures, and it's, you know, like it's a whole thing. And so I would consult with your council on state law about your ability to discipline or enforce policies for someone on out of work behavior. You can certainly have a conversation with someone, but what they do in their private life, in their private homes, in their private business is not generally something that you can enforce against.
Agreed.
It's tricky, right? Like, cause it seems like, I mean, it's like, you know, like one drop in the pool infects everybody, right? So like, it's this tension between the practical of like, okay, we can't, if you want to go out and go to a club all weekend, there's not tons that we can do, but also the practical result of that is you're going to come back into the workplace and likely be a carrier. So it's a huge tension.
One of the things to consider in that is if you've had them fill out documentation that says, I'm not comfortable being around groups of people, and then they go out and they're in the workforce, but they're willing to be groups of people, then, you know, depending on, again, check your jurisdiction about what you can rely on. But if you're relying on a falsification of their application for leave versus what we saw on Facebook, you know, depending on how you couch that discipline about what, are you really afraid of being in groups of people because your office is 5 colleagues that you go into versus the party we saw you at had 50. So you depending on where you are, but again, reach out to council to figure out what your state rules are and what you can use and how you learned of the information.
Yeah. And then, of course, I think we covered this in prior webinars, but short of job modifications or leave requests, there's all sorts of workplace modifications that can be done. And we know most of you have already implemented these. And the key here that we're increasingly seeing is just working with your local public health agency to see what they think you should be doing in terms of relocating, restroom assignments, We are seeing some requests for stipends to cover transportation costs, if that has differed, and we're gonna talk a little bit more about what needs to be covered in terms of payment to employees when we get a few slides ahead. So those are all
masks.
Oh,
Talk about the masks. I'm not letting you off this one, Natasha.
Okay, well, Liz in a few slides is also going to talk about masks, but there's this huge question of, do you have to provide masks? As an employer, do you have to provide masks? And, there's no clear answer on this. And we know in California, we're cognizant of Labor Code 2802 that says you have to reimburse your employees reasonable expenditures. And so there's this question of, if you're going to require masks, do you have to buy masks for people? And, some are taking the position that, hey, we require people to wear shoes and pants to work, and we don't buy those for them. And Liz's point there, which I think is super interesting, is that's different than personal protective equipment, right? Like, we don't require people to bring their own lab coat or to bring their own safety goggles. So, you've got a compliance decision here as to whether you're going to provide masks. Do you have access to masks? Do you have a contract for masks? Like, there's a whole lot of logistics that go into that as well. But I think at least having them on hand for people who forget or who simply refuse to buy them is a minimum that you're going to want to think about implementing. How's that, Liz?
That's good. Thank you.
Right. Who knew 6 months ago we'd spend so much time talking about face coverings?
I know, right?
Yeah.
So moving on, I think then the next piece we're going to talk about is people refuse to return to work. How do you respond?
Yes. So, and this, tends to be closely related to people who don't want to wear masks, who don't want to come to work. There's all these emotions in terms of what people, we're really seeing everybody's emotions play out here. So if they don't want to return to work, so first of all, do you have a temporary modification policy? What's the reason that they're invoking? Is it a disability? Is it a fear-based thing that could be run through your temporary modification policy? But then we have campuses that have reopened, and they have reopened in person, and they've got people there. And then it's a decision point of, essentially, if it's not an ADA thing, then it's a temporary modification request, and you got to go through that analysis. Do we need you on campus? Do we have work available for you? Could we do some of that remotely? Like, really going through those. But we're seeing sort of a very black and white, I'm not coming back to campus. You're seeing it play out on Twitter in terms of I won't be forced to return to campus. So you got to get past that emotion and unpack, is this a disability? Is this a temporary modification? You can have some flexibility. The local public health agencies, the California Department of Public Health, are all encouraging flexibility, but it's got to be consistent with your overall academic plan, right? That's got to set the tone for how you make these decisions. Otherwise, you're just engaging in decision-making against benchmarks that aren't clearly articulated. So those who cannot be accommodated can be required to return. Nobody wants to hear that. It's a tough sentiment. It's tough to roll out, but you can say you're required to return to work or face termination. With the result of that, just so people are aware, if you're going to draw that line, is that can be viewed as job abandonment, resignation, and therefore that person who doesn't want to return to work and is told that they need to return may not be eligible for unemployment insurance benefits. So that's a practical consequence of that. So Liz, I see you waving at me.
This is going to really, I think this is really going to come up. We have the issue right now. This is twice. It's going to come up now about who doesn't want to come back right now. And then there's people who are going to say, fine, I'm going out on one of the leaves for the 6th enumerated reason. And they're going to exhaust their 12 weeks. Then you're going to have to try to get them back in. Now, they've kind of kicked the can, right, down 12 weeks. Now, and so this is another piece where you're going to need to have policies and procedures that are consistent. When are you going to give an exemption to returning at the end of that 12 weeks? Who gets to go out on an unpaid job protected leave, or who's going to continue? This is another piece that I do think the battling who has to come back in and the standards that you use, whether it's a decision being made now or a decision being made when people exhaust their 12 weeks of leave. So 3 months from now, we're going to be having this conversation. Thinking about that now, standard protocols and decision-making practices, so that you don't end up in a discrimination claim that that you're not being consistent in how you apply that. So this is a pause point that everybody needs to be getting prepared for. If you're not addressing it right now, you are certainly going to be addressing it in a larger capacity at the exhaustion of the 12 weeks of leave.
Yeah. Yeah.
And then I'm just going to touch quickly on some of the privacy pieces, because I know we did talk about this on our last one, and I know we want to get to answering some of the questions. But so your privacy concerns come up. What are you going to disclose to other employees? And how do employees find out about private, your private medical conditions? So, the issue is when you're doing a accommodation or ADA accommodation request, the exact medical reason often isn't shared beyond directly within HR, even if, and maybe they don't get the full medical reason. It's certainly never shared with the supervisor. The question is, this is the modification they're requesting. Is that reasonable within our workforce? Can we, but the exact why is not shared. What's interesting, and we need to have that exact same confines over if somebody is asking for a COVID-related modification. We'd be careful. Do not be sharing because they have symptoms or they tested positive, because that crosses over into medical information. So the conversations need to be as bland as they are with ADA, saying they're asking for a COVID modification for intermittent leave. Don't share that it's because to care for their mother who is sick or the kid who's out of school. We just need to make sure you're not oversharing that information. It's really important. The other place that the medical information is going to come up is, what do you share with employees because they've been exposed? So you have an individual who's come into the workplace, they have subsequently reported that they tested positive, and you need to share that contact tracing type information. Again, you don't share exactly who. There's ways to do it, to say that you were in a meeting or in an area of the building from 12 to 2 on Thursday, and we have information to believe you came into contact with somebody. Be careful that you're not giving so much detail that they immediately know who the individual was. So these are just considerations. I know there's a lot of office chatter about, who tested who. Just don't play into that, and be as bland as possible in the information that you share. Yeah.
And just real quick, I've noticed, depending on your jurisdiction, your public health agency, they may want to do the contact tracing. They may have washed their hands of the contact tracing. I've noticed some very strong opinions on what the local public health agency expects that the employer will do and disclose. So if you're not already working with your local public health agency, that's critical, because some of them are saying we need to learn to live with the virus, and things that the employer would have notified, the local health agency says, I don't. You walked by somebody once who may have been diagnosed with COVID. We don't think that you should do a campus alert. So they're trying to get people to learn to live with the virus, to think about when things are going to need to be disclosed. What's the difference between actually being exposed and significant exposure that you need to disclose? So I work really closely with your public health agency on this.
Speaking of sort of public disclosure, do you want to tee up, what are your thoughts on the CLARI Act notification requirements?
Yes. Okay. So consult with your counsel on this. But in April, the department, in the series of guidance directed at mostly a waiver of other Title IV requirements, said that institutions did not have to issue a CLARI warning for a threat to the campus for COVID if they had a banner right on the front page of their website that directed people to more information, to essentially say, COVID's dangerous. These are the steps you need to take to protect yourself. that was encompassed within a larger package of guidance from the department where they waived some specific Title IV things. That guidance expired June 30th. So then it became the question of, well, now if we get a report of COVID exposure on campus, do we still need to issue a Clery Act notice? I think that that particular piece within that larger guidance was a position about how the department would view COVID, and didn't necessarily, I think there's an argument that it didn't necessarily expire on June 30th because there weren't any other deadlines associated with that. So what we've been talking about is making sure everybody's got a banner right across the front of their website. You know, you can put in your logo, you can put in your colors, whatever you want to do to make it look nice, but to continue to warn people via that banner. And then it's a much more nuanced analysis of, under Clery, do you need to do a campus-wide under your rave system blast, or do you need to do a smaller blast to the department? Then this starts to get into, what does the local health agency require for contact tracing? What do they want to be announcing? They don't want panic. So they don't want every time you get a Clery or a COVID diagnosis on campus, you do a Clery warning. The other thing is, remember, the function of Clery, and I will argue this to the death if it comes to this, maybe not to the death, but I will argue is Clery is designed to warn people of an imminent threat. We don't issue Clery warnings for the flu. We don't issue Clery I mean, you know, if you've got a localized case of meningitis, sure. But it's not practical to issue a Clery Act warning every time you're going to get a diagnosis, because for our campuses that have reopened in the Midwest, that would be, you know, a lot of different warnings. So I mean, it would be like it would just, anyway. The other thing is, under Clery, there's a legitimate question: is this still something you need to warn about? If you don't know that coronavirus is dangerous and a threat to yourself and the steps to protect yourself, I don't know that a Clery warning is going to help you. Like, anyway, Liz. I'm getting feistier as this summer progresses.
In short, I agree completely on the Clery notice piece. I think the banner is what should still be doing on the clear notification, but not a repeat it every single time somebody is diagnosed.
Yeah, I mean, all of this is so tricky. Like the questions that we're getting about, like, can you require someone to take a test? Can you require someone to disclose the results of a test? Can you require someone to take a test if they've got symptoms? Like all of those things you normally couldn't do, you now can do under the EOC. All of the things you couldn't do or used to do before, like it's all turned upside down. So I think you just gotta like really think through the privacy ramifications of each and every action. So with that.
With that, I think we can turn it over. David,
some questions.
Do you want to field the questions for us?
And I've been sort of monitoring the screen here and trying to keep a list, because we have gotten some questions from the audience, and thank you. And those that have additional questions, please put them in the chat box and we'll try to do it. But we've gotten some questions that do track along the three categories we've talked about: disability and protected leave, workplace modifications, and what you just were discussing, privacy and disclosure. So I'm going to start, just take them in the order. I've got a couple of questions on the first topic, questions on disability and protected leave. First question. So if an employee discloses that they have a condition that is covered by the CDC list of vulnerable populations, are they entitled to work from home as a disability accommodation? What if my institution cannot accommodate their request to work because they are needed on campus? And there's some subparts to that, but I think you have the gist of that question. Who would like to start with that? Liz, do you jump in?
Yeah, I'll jump in. And if they've only disclosed that they have if they are a list of vulnerable populations,
right.
No, you are not required to give them a reasonable accommodation under the ADA metrics of a reasonable accommodation. But what are you wanting to do? What is the exact reason that they've asked for it? Now, if they've said that they are an individual at high risk, which is a more nuanced than just a vulnerable population, if they said they're a person at high risk because they smoke, I'm going to still say probably no, right? If they say it's because they smoke and they have significant lung issues that make breathe and makes them more susceptible to illness, then you're going to have to say they're still probably not an individual disability, but what have you said in your policy and how are you going to treat those individuals? So it's a nuanced decision, and you need to look at how you've decided you're going to treat people who may have increased vulnerability, but not quite got to that level of disabled, individual disability under the ADA.
And then if they do disclose something that would provide them protection under the ADA, Section 504, California FEHA, then that's not the end of the analysis, right? So what all that's doing is triggering the ADA interactive process. And then they need something saying, this is what this person needs in order to be able to perform the essential functions of their position. And then you say, well, we can't have you work from home, or we can have you work from home. You got to go through that process. Here's some other, we can provide you additional PPE. We can provide you additional plexiglass. Like, you go sort of through that, and then you have a decision to make as to whether or not you need to grant that request, or whether they're going to provide a different request. So it's not that they're necessarily entitled to it. So where you start and where you end are often very different. And then just really working through that interactive process. It's going to that is always an individualized assessment. Right. Disability is always individualized. Yeah.
One thing I would add to those excellent points by both of you is that if you have multiple people involved in the decision, particularly because often people are working virtually, you need to have some way that you're either tracking the responses so that you say consistent and that you're not doing one-off responses that will come back to haunt you. So, okay, I'm going to move to workplace modifications, the second bucket, and we have a question. In essence, it says, thanks for the discussion on the face covering points. Here's the question specifically. If the county requires masks or face coverings, do we have to supply them then?
I lean towards yes.
Both answer at once.
I lean towards yes.
You would say yes. Liz, yeah. What are your thoughts? The county requires face coverings. Do you have to supply?
Are you a public or private entity? If the county, if the government, if your state or county is requiring face masks, if you're a public entity, probably more likely because you're part of the state or the county. If you're a private entity, that's a state requirement. You're not putting it on your employees. It already exists, so you may not have to require it. You may not have to provide it because somebody else is obligating that coverage.
I think increasingly in so many jurisdictions there are a growing number of face covering requirements by the jurisdiction. I think that the default is that people are to supply their own. It is a mandate for public health and safety that you present yourself appropriately covered, but to a point that I think, Natasha, you made earlier, it probably makes sense to have some on the ready. So, Liz, reminder, we do have a mandatory face covering rule. The state does, the county does. You didn't come with a face covering here. Here's your face covering for today so you can go to work. Don't do that again. Exactly. Thank you. Perfect. Perfect. All right. I've got a couple, checking my rosters here, we have just a minute. I want to just hit a privacy and disclosure question. The question, this is from one of our listeners, is it not a violation for us to give a city address of those who tested positive because they have other records to connect the address with a name through the city water records or other records? I'm not sure I fully understand that. I'm reading the question as presented. Isn't it a violation for us to give a city address to those who tested positive because they have other records? The city has other records that connect the address with a name through city water records, city or other water records. So the question is providing an address.
Okay, I can try to field that. So if you are, it sounds like the question is about whether the disclosure is to the local public health agency.
I think so. I think we can read that into it. Yes.
So having not known very much about public health agency jurisdiction prior to this pandemic, and having spent a lot of time getting acquainted with that, there is enormous latitude. The public health agencies have essentially unlimited power. There's enormous latitude. There's usually exceptions in privacy statutes for disclosures to the local public health agency. I think, check your local jurisdiction, but I think that there's probably, they would expect you to, they would demand you to provide that information so that they can engage in contact tracing. I think there's going to be a lot of permissiveness there.
The overarching rule that we're seeing develop in this circumstance is that some of the normal privacy considerations, you saw this in the EOC, you see in the others, yields to facilitate the public health and emergency response in disclosing certain information. Not to over disclose, but to appropriately and necessarily disclose. So I think that's a good takeaway from that question. Okay, we are actually right on the hour, right on time. Any closing thoughts? Natasha, I'll let you go first, and then Liz.
Thanks for joining us again, and thanks to Fortney Scott for hosting us again. It's been a lot of fun. As you can see, we could talk about these issues for hours. They update daily, so it's something to keep an eye on. And then I would just make sure that you are thinking all of this through and being prepared for sort of from now to December, what the semester looks like on your campus if you've got multiple terms, and how you're going to handle all of this so that you can get out ahead of it.
Liz?
Also, thank you all for joining us. Please email us. Let us know what you want to hear next time. We'll listen. We'd love to hear some topic lists, and let us know what you're interested in, and we'll be back here talking about it. So thank you all very much.
Thank you both very much, and thank you everyone for joining us. Another terrific and very informative webinar. Thank you so much.
Bye.
We would like to thank you for joining us. As a reminder, you may view the previous briefing on Fortney Scott's website at www.fortneyscott.com. Everyone who registered today will be registered for all future higher education focused briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@fortneyscott.com.